simultaneously with the case. And there is the focus on precisely, which the law requires, precisely the city needs to show how, if we receive the information that we're asking, that the effectiveness of the city and the performance of its duties would be significantly impaired. That's what the standard is. But also there's it's on some level,
Very sorry.
it's been a little bit of a shocking eye-opener to me to see a situation where we do have a large parcel of city-owned property that has significant, historical value. We have city employees that have available to them a lot of tools to assist in the economic development and bringing jobs to Tucson. And that is a good thing. Our people all involved, there's no dispute about those being good things. But we have a situation where the staff, in kind of an astonishing way, has the freedom to develop things and negotiate, develop terms, do a phenomenally lousy job in analysis and negotiation. I mean, everybody.
Is that the issue today?
It is one of them.
One of the issues is how well the city's doing its development job?
No. I'll quote from this Arizona Attorney General's opinion discussion. And it says, the core purpose of the public records law is to allow the public access to official records and other government information so that the public may monitor the performance of government officials and their employees. If they're giving away the house and they're not doing their studies, they're not talking to other people, they're not checking numbers, those other things, then the public has a right to know that, and it goes to the core purpose. I didn't invent these words. This is the core purpose of what the Attorney General says our public records laws are about. That's I-91-004. And it's, I think, I mean, there's no question, even the city in some of its documents cites this. The Phoenix newspaper versus Keegan says the public's right to know any public document is weighty in itself. That's our rule in Arizona. And that public property itself is involved is additionally weighty. That tax benefits and other incentives and favors are involved. This is public money is additionally a weighty matter. That conflicts of interest among consultants, lawyers, the city is blind as to who's behind the curtain on Trio. Trio knows these things, The city in this situation, the only group that doesn't know what the city offered Grand Canyon is they gave it to Grand Canyon. Grand Canyon knows what the offer was on a specific piece of property dealing with specific factors that are no longer under consideration, that were dealt with on the staff level itself, were never offered by mayor and council, never approved by mayor and council, never subject to the negotiations by mayor and council. So it's, the only, when the city is put to the test of saying, okay, what is the specific that's the problem with this, the specific is, geez, when you negotiate, you need to, during that process, keep it secret. Well, we're not objecting to this in that case. We're not denying their right to negotiate with the University of Arizona, whatever they did. There may be reasons relating to that, why that's a good thing. What they're saying is here is after there's no negotiations, after it's not on the table, you can't know what city staff thought was a good idea to offer. How does that prevent the city from carrying out its functions? If they were doing a bad job and the public knows, it would improve the city being able to carry out its functions in the future. If they weren't authorized to do stuff in the first place, that's not going to affect the city in the future. And the astonishing thing is the city does a lot of deals. Remember the Town West deal, the Depot Plaza deal, the Thrifty deal, the Martin Luther King deal, the deal. Stack up the deals, and those deals, every provision is in them. And if I want to know what was the negotiation underlying that, those are public records, and I can get those. And I have on some of those deals in the past, because those things are public record. So everybody can look who's negotiating with the city and say, what did they do on this deal? What did they consider on this deal? What's the city standards on that deal? What are their standards on when they do whatever they've done in those deals? Those are complex deals. They're all a matter of record. So the city's saying, yes, every one of those deals, it's a matter of record what we did. But what staff suggested we ought to do in this deal that's not on the table, that's over, you can't see that. And they've got the duty and the requirement and the burden to specifically show what that problem is with that. And they certainly don't. They just do stuff like, well, companies like things to be secret. That's cool, I'm sure they do. I like my affairs to be secret. I like lots of stuff to be secret. But we've made a public policy decision in this state that all public records can be seen, can be examined, and we can get copies. That's what the legislature's done. There is not a confidentiality exception to our public records laws.
Objection, that's a misstatement of the law.
The case that the case that Mr. McLaughlin has put in a letter to my client that they really like this one is the Pima County, Carlson versus Pima County case. And that's kind of interesting because...
I've read it. If that was streamlined, I have read it.
Okay, so what they little stamp said something secret or confidential not to be disclosed. Our Supreme Court in that case and other cases said, look, we don't care what stamp you buy, we don't care what you call it. What you have to show is not what you call that agreement, but what you have to show is that something specific there prevents you as an agency, impairs the effectiveness of the agency in the performance of its duties. The city has a duty to protect city parks, to protect city property, to husband city resources. So they need to show in this document on the deal that's no longer on the table, how those would impair the effectiveness of the city in performing its duties, and it has to be significantly impaired if disclosure of that information is made. Those are those are the legal standards, and the city has not met its burden. Incidentally, there's it's on another case, A.H. Bello Corp. Versus Mesa Police Department, 202 Arizona 184, says the public interest in disclosure increases when there's no other available way to obtain the information. So we're dealing with a very strong state statute. We're dealing with importance of public property, public taxes, the kinds of, and dealing with important, unusual, unique historical property. All of those things together. And those all go to show the public interest and the public's right, and the city has to specifically point out what it is about some suggestions that were never acted on, never approved by the city council, is going to somehow prevent them from doing their job dealing with city property in the future. It's an extremely high burden, and you've heard none of it. Thank you.